Hi, my name is Joe Salazar, and this is my presentation for discovery requests for civil litigation 2. What is discovery? Discovery is the formal process of exchanging information between parties in a lawsuit. Its purpose is to uncover facts, clarify claims and defenses, and prepare for trial or settlement. As far as the scope of discovery, think of discovery as having 3 layers of information. At the center, we have the most important material, evidence that is directly relevant and admissible in court. This includes things like signed contracts, medical records, or eyewitness statements. The next layer out includes information that might not be admissible itself, but could help us find admissible evidence. This is where most of our discovery efforts focus, like emails, internal communications, or background documents that help us understand the facts or identify key witnesses. And the outer layer includes information we're not allowed to access. This includes privileged communications, attorney work product, or irrelevant material that has no bearing on the case. These are protected by law and fall outside the scope of discovery. Common discovery tools include interrogatories, requests for production, requests for admissions, depositions, and subpoenas. Each discovery method serves a distinct purpose in building a strong case. By developing clear and focused requests, a party is able to collect relevant information and prepare effectively for trial. These efforts form the foundation for presenting a party's arguments and addressing the opposing party's claims. Now, following this slide, I will highlight a few examples of different discovery tools commonly used in litigation. This overview will provide context before I focus on my selected set of documents related to requests for admission. So the first example is a request for production. A request for production is a discovery tool used in litigation where one party formally asks the other to provide relevant documents, electronically stored information, or tangible items. The goal is to obtain materials that may support or challenge claims, clarify facts, or aid in resolving the dispute. This next example is a discovery subpoena. A discovery subpoena is a pretrial tool used to compel non-parties to produce documents, tangible items, or testimony. Common types include deposition subpoenas for testimony, as well as subpoena duces tecum for documents. These are vital for gathering evidence from outside parties during litigation. Fun fact, the Latin phrase duces tecum translates to you shall bring with you, highlighting that the subpoena's primary purpose is the production of evidence, not just the witness's testimony. This type of subpoena can be used by parties in a lawsuit to obtain relevant materials from non-parties, such as bank statements, emails, or medical records to support their case. Now, the documents I submitted for the purpose of this presentation are a request for admission and a response to a request for admission using the Emerald's Catering hypothetical. A request for admission is a discovery tool used to ask a party to admit or deny specific facts, document authenticity, or legal conclusions. Now, the purpose of the request for admission is to narrow issues for trial by establishing agreed upon facts. Also, it helps avoid unnecessary proof of facts that are not in dispute, and it saves time and costs during litigation. Here are some of the specifics of the request for admission. Who is included? Terms like you or defendant refer not just to the company, but also to its employees, agents, attorneys, and anyone acting on its behalf. In this example, since I used the Emerald's Catering hypothetical, the event is defined as the specific fundraiser held on January 15th, so there's no confusion about what the questions refer to. As far as why it's so formal, the language ensures clarity legal precision, and enforceability. It also sets the stage for holding the defendant accountable if they fail to respond properly. Second part of my documents is a response to request for admission, which is a formal written reply to a discovery request in which a party is asked to admit or deny specific facts, the authenticity of documents, or the application of law to facts. Here, if a party admits, they confirm the statement is true and undisputed. If the party denies, they assert the statement is false or inaccurate. If the party states lack of sufficient information, they declare that they cannot truthfully admit or deny the statement after making a reasonable effort to investigate. When a party receives a request for admission, they are required to respond within the time allowed by law, which is typically 30 days. If they fail to respond, there are serious consequences. 1. Facts are deemed admitted. If a party fails to respond, the requesting party can file a motion to deem facts admitted. The court will treat each fact or document listed in the request for admission as true or genuine, effectively removing the need to prove those facts at trial. Binding admissions. These admissions are conclusive. The responding party cannot later introduce evidence that contradicts the admitted facts unless they successfully file a motion for relief from admissions. And monetary sanctions. Courts often impose monetary sanctions on the non-responding party, including attorney's fees and costs for filing the motion. In summary, the discovery process is a critical phase in litigation designed to promote transparency, facilitate the exchange of relevant information, and ultimately support the fair resolution of disputes. By understanding and effectively utilizing the various discovery tools, interrogatories, requests for admission, document production, and depositions, legal professionals can better advocate for their clients and uphold the integrity of the judicial process. And that is it. Thank you very much for watching. I hope this presentation helped you discover the value of discovery.